difference.
These clauses are challenged by me. In that case, the clauses are not challenged. That's a vital distinction. So, in any case, this should be heard whether your lordship gives as its own standalone, whether your lordship has in that, because this requires, that'll take 5 seconds, matter can't be heard today. Your lordship has a line of cases that where 1 out of 3 are to be appointed, selected by him. He will give me 3 names, I'll select 1. More than that, I can't make a claim unless a final bill is issued, and a final bill will be issued or not issued according to his discretion. Those clauses are under challenge. It makes it, but arbitration is supposed to replace litigation, although it's in shambles. Your lordship knows that.
Anyway, my lord,
But
I have an
it is-
answer to that
No,
specific.
one second. Therefore, arbitration must have a level playing field, is the issue here. If you are but kindly indicate it's, I'm not accepting it's the same. Now, should we just keep that separation? Just take my contention, put a sentence there. Tomorrow it will be said.
We will say,
That's
post this matter for
Yes.
final hearing or
Yes,
some date.
certainly.
Then we, SLP civil number, give the number.
Okay. And other tagged matters, my lord, your
One
lordship.
sentence your lordship may put, Malus. Otherwise, later on there'll be a problem. However, Malus, I submit that these are different. This is different because
That you can
all
do
the
the argument,
challenge-
only being
We are not-
heard together. that's
We are
all.
not tagging those matters with your case. Your case is separately taken up.
Very well.
Those are listed on the same day.
Same day, yes.
One after the other.
Otherwise, we'll hear them
As
separately.
long as it's not tagged. Very well. The date is coming, he's not changing it.
Item 47.
Same day.
Please await it, sir. First respondent will come.
My lord, I am appearing for respondent in
My
this
lords, I
matter.
appear for the petitioner in this, my lords.
So, my lord, I am appearing for respondent in this matter, my lord. So I need a 1 week time to file my wakalat and reply in this.
You are appearing for both.
Yes, respondent 1 and respondent number 2, both.
Always 1 week time granted, next Monday.
Much obliged, my lord.
Item 48.
Please, my lords. I was appearing for the petitioners in this matter. As per the office report, my lord, service is awaited.
That's a
10:20 on 13th of July, only they sent.
All right, which comes as per the office report, service is awaited. Which comes also.
Please, my lords.
59, your lordship, as per your lordship's last order, we made the payment with regard to Provident Fund. However, gratuity has not been paid. But moreover, your lordship, I will need to file affidavit in this case. Reason being, he had the OD facility, and when we credited the amount, it was automatically debited, your lordship. So we may be given some time so that we can file an affidavit that he had the OD facility and loan also. So we had to adjust that amount. We will place on record with affidavit, if your lordship would allow. In both the cases, same position.
My lord, I am not sure whether they can recover it from my gratuity and the provident fund. Because if they want to file it, my only prayer is that your lordship may kindly fix the matter on 24th of August, my lord. There is a statutory bar, but if they want to file, I file, my lord. I'll come back on 24th of August, subject to your lordship's convenience.
Loan amount. Provident fund.
And in the one case, my lord,
Your
the
lordship would say that gratuity.
dues are pending from the day when the writ petition is decided. They have not paid it, taking all this technical pleas. And these persons have removed from service long back without any.
2008.
You want to
Yes.
file some?
Affidavit, reason being, my lord, your lordship had directed us to pay gratuity and provident fund. We credited, however, they had, both the employees had OD facility as well as loan account. So we have adjusted that amount. We would like to have.
When you do that, that is the point. You should not have done it.
So circumventing it.
Later.
Yes, Mr. Counsel, you cannot rewrite our order. There was a clear direction on you to pay the provident fund and gratuity subject to the outcome. So you cannot rewrite by saying that we will pay only to the extent we adjust the OD facilities of the respondent. That would be, if you felt that way, then you could have filed an IA for modification.
Absolutely. That is,
Then
my
that is
mistake.
not the
But
right
they
approach.
did not paid even a single penny.
So
for last
please
15
release the remainder amount
Very well.
and file your affidavit.
My lord, my limited prayers since I come all the way from Guwahati. If your lordships will kind enough to fix the matter on 24th of August, I'll be there in person.
By 49 posts, Maliko, counsel for the bank sheets and granted 2 weeks time to file the compliance affidavit. Item 50,
In 49, well, 49.
24th of August, Monday, I'll come on Sunday.
Lordship, in 49, with all fairness, if your
Amen.
lordship would say, we have not adjusted gratuity, if your lordship would say, we will pay the gratuity, well, within a week or so.
Please do.
In 49. In
Even
49, well, we
Provident
have
fund also
adjusted
can't be-
unfortunately, but in 49, we have not done so. If your lordship would say, we will pay the gratuity, whatever is there.
The
Then
day that you have adjusted, you should immediately release it to the other.
Release it to both of them.
we will instruct the client. See,
Well, even
If the contempt application is taken out, we have to take a very
I
serious.
understand. I'm so, I'm so grateful, lordship.
15 lot is section.
item 50.
Yes, my friend on the other side and I, Lord, we've discussed something, Lord, that we'll try and sort it out, Lord. My only request, Lord, subject to what your lordships have to say, that it be referred to somebody to bring about some settlement, because we've had bilateral as such talks which have not worked out.
Mediation.
So somebody in Bombay, Lord,
If you need a mediator, we can appoint. If you can mediate yourself, you do that.
Lord, we
Yes,
tried
Lordship,
that in
that's-
the past, but that's not happened. So I'm requesting your lordship could appoint somebody as a mediator, Lord, in Mumbai. So that would, Lord, and this matter would stand over by about 3 weeks, Lord.
Your lordship,
How
as
much
you,
is the amount?
I'll just tell you, lordship, Lord.
your lordship is under 10 crores, a very small value claim, your lordship. So I appear for the respondent. We're willing to sit across the table and settle the matter with them. So my request is the 3-week adjournment with subject to a bilateral settlement, your lordship. The value of the claim is very low and it can be discussed and settled between the parties.
It's not,
$8, $500.
we've tried it in the past, it has not happened, and that's the only reason, Lord. There's no other reason, Lord.
Your lordship, a short adjournment, if it doesn't happen, we can always go to
So
mediation.
stand over by 2 or 3 weeks, Lord. There's no difficulty on that, Lord. It's only that normally, Lord.
Your
Somebody
lordship,
in
my
Mumbai,
request
if your
is given the
lordship needs
value of-
50 minute उसको बोलने दो बेचारे को क्या कहते हैं?
I'm sorry.
Your lordship, given the value, the request is let us have a 2 or 3 week adjournment. We'll try and settle bilaterally. If that's not possible, we'll go to mediation, your lordship. But let us
I
the
will do
first
it myself.
try and settle, your lordship.
Very well, your lordship put it off by 2 weeks, Lord.
After 3 weeks.
Great, very well.
Great.
Whatever question of bias, you can independently appoint from the court a arbitrator, it will be an end of the matter.
Lord, that's not happened, Lord, your lordship. But yes,
Point.
your lordship is talking about the mediator.
You're talking about the arbitrator, why unnecessarily going to this rigmarole?
Lordship, there's no settlement. We
Item
discussed.
There are no, we'll hopefully come with a joint name.
Yes,
Grateful.
grateful, your lordship.
Well, it's item 51 is a section 11 petition where your lordship said issued notice, but nobody's entered appearance so far.
Actually, in the reply notice, they never opposed arbitration. They never.
Milords, I appear on behalf of the respondent in this matter, Milords. Milords, I have just received instructions in the afternoon today. Milords may grant me 1 week time to file my appearance and reply if any. I don't
May
have.
I just, may I place just one request?
Next Monday.
Manoj, may I place just one request? If the parties can sit down, be directed to mediation, the claim amount is only about 30 lakhs. So therefore, Manoj, my request would be if parties can be placed before a mediator, we can come about a settlement. There is scope for parties to arrive at a settlement here.
He'll come. He says he's just received.
Having regard to the amount in dispute, we direct the parties to approve the mediation center. A mediation center attached to this court. The matter may be assigned to some seasoned mediator. Post this matter after 8 weeks. 8 weeks, meanwhile you try for mediation.
Grateful, Manoj, grateful.
Grateful, Milords. Grateful.
Yes, my lords. My lord, here, but as per my instructions, the SIR might be over by October end or November. But your lordships may, my lord, bind us down to hold the elections in December. Otherwise, also, my lord, I have taken instructions. There are torrential rains, my lord, in entire Maharashtra. Situation is my lord, can I consider, my lord, request your lordships to consider, my lord, this order, my lord, which my lords were pleased to pass in Karnataka, my lord, where SIR was going. Your lordships, my lord, are aware.
No, Karnataka, it was only fresh election. Here on the basis of the original electoral roll,
Yes, my lord.
majority of election have already been held.
Yes, my lord.
So that's why we were thinking that same electoral roll can be.
My lord, there might be some
Millets.
difficulties from your lordship.
Even the entire staff millets, I'm
for elections
representing
to
election
Jalna
commission of India. They have been in SIR millets, all the district collectors, all the revenue staff, etc. For elections, they have to part with, then that will derail the SIR millets, which is time bound as my lords have observed. Once we complete millets, 30 days could be there for appeals and other things. Thereafterwards, the state machinery has its liberty to proceed further.
And all district collectors and district administration is really looking after the relief work because of the unprecedented rains in the.
Yes, I'm concerned for Jalna and beat district elections for the local authorities.
It is the same matter where Madam Indra has been.
Yes, sir.
Yes. Here the elections are held last time in December 2021. I leave it to your lordships otherwise. The application was for limited
There
purpose.
is a breach in 20 of that 50% cap. That is our
As
contention.
far as these Jilla Parishads are concerned, they did not
There is
breach
no
the
breach.
50.
Election in December.
Administrators are there, not that the earlier body continues.
So there is no breach even as per the new regime.
Even if section 12(2)(c) has been read down, despite that, they are giving a 27% reservation to the
We
OBC.
can think of deciding the main case itself then.
Well, that also is
Can
one,
also be done that.
can be
For
done.
that.
So otherwise
They
there
can
is.
reassess it because the 12(2)(c) has been read down. Despite that, they are giving 27% reservation to the OBCs as a matter of rights.
That's a matter to be considered on the merits of.
Yes, but it requires consideration. Otherwise, there would be election. Again, it will create a serious anomaly because after election also, because it has happened in the past.
But in my application, I have placed the government data on record.
They could have done it earlier.
As far as two Jilla Parishads and local bodies are concerned, Jalna and Beat districts of Maharashtra, there is no breach of 50%. So at least where there is no breach, those elections can be taken up.
That was our earlier order.
Yes, so in spite of
50%
earlier
can
order,
be held and they would,
Yes.
as you,
Lordship,
there will be.
after that order,
Subject
these are
of-
two Jilla Parishads of which elections are not held, in spite of not being in breach, my lords.
Now
We are already
Classified
in-
municipal-
we are
municipalities,
already
because there are
almost in
breach
August.
2 municipalities only, but whereas in
It's
Jilla
a 3
Parishad,
months down the line,
balance-
my lord. December is not far away. And my lord, rain is an independent reason. My lord, that's the genuine difficulty, my lord, in the administration.
We are not against the election, my lord. They can, till December, they can do all these things. No, they can fix it in within 50% also. Because in municipalities, there was a breach in only 2 municipalities, whereas in Jilla Parishad, out of 34, there is a breach in 20. And PS, it is a 211 Panchayat Samitis.
Now the only way out is first we try to decide the main case. If the main case is not decided, then we will think.
Then your lordship can always consider the same solution.
We missed it somewhere in August and.
Okay. Great.
Item 59,
I'm okay.
To be tagged with 50, same.
same. Rahul.
Yes.
59, Manoj, is about the Zilla Parishad presidents. So Manoj, there the percentage of 50% has been increased. So therefore that is different. There is a notification issued on 9th of September. Now please have that at page 37.
So we are listing the main case itself, Purati.
Manoj, your lordships had detagged it. Your lordships may have it on some other day, but on the last occasion, 3 days back, your lordships had detagged it and kept it separately. So it's 59.
President of the.
President, this was with the main matter earlier, but your lordships were pleased to detag on my request. So if your lordships want to have it on some other day, I can have it.
It may be kept on the same day, though remain detagged on the same day.
Yes.
Yes.
Separate matter, separately.
Very good. Great.
Item
Obliged.
60.
Yes, now, Manoj, in item 60, we have been constrained as a respondent, number 2, to take out an application for variation of an interim order which was passed ex parte. And that your lordships will just see was an interim ex parte order passed on 3rd July 2026. So first just see that order And I want to just indicate what has happened here. This is Your Lordship has the order of 3rd July. 3rd July passed by our court.
Yes.
As you have noticed that it is ex parte. Second, para 2. Learned Counsel submits. Your Lordship has that. Construction is going on. Now, Avenue D2, Avenue K1, Avenue P, Sector 2, and Avenue CFC 8. According to Learned Counsel, there is no environmental clearance for the constructions in these segments, and all that has happened is an application has been filed for an environmental clearance certificate. Issue notice returnable. In the meantime, status quo shall be maintained and no construction shall be carried out in these segments. Now, I want to just mention 2-3 things. First, this is an appeal coming up from NGT. Now, NGT ex parte dismissed their application because they found it premature, etc., and found no. So I didn't even have notice of it. So there was no question of my filing a caveat, etc. So then suddenly this order comes to be passed. Now, I want to just give you a little background. First and foremost, I want to just inform the court that we have, I'll just hand over a table. We have an environmental clearance, which is, just give those that table. We have an environmental clearance for all 4 segments, and the ongoing construction is within the limits of this. So this is a gentleman, he describes himself in his petition, etc., as being a resident of this layout. At least our information seems to suggest that he may not be a resident, but let's for the moment assume that he's a resident of the layout. Now, before I come to the table, just note 2-3 things. Number 1, the project commenced in 2007. 2007. Number 2, there are a total of 368 buildings. 368 buildings, out of which 319 are complete with occupation certificate. 319 buildings are complete with occupation certificates.
Out of total?
Out of total 368. Project started in 2007. 368 buildings total, out of which 319 buildings are complete and occupation certificate is received. Please note, there's no complaint on this. All constructions according to sanction plans, all constructions and all development after obtaining Maharashtra Pollution Control.
According to you, the earlier environment clearance covers a larger layout.
So now I come straight to the point. All right? Just take up this table. Just take up this table. This table which I just handed over. Please note. Keep it. Now, all my construction which is ongoing has suddenly stopped. Give it.
Saying that is outside.
Which place?
Sorry? It's
Projects are at which place?
Virar, my lords. It's in Thane district, Virar. Palghar, is it? Palghar. Now, Your Lord, that is on record, but this is a little bigger plan. Your Lordship has this horizontal table. So now just let me explain it first and foremost. Please see the first column. We've given you the avenue number. So these are segments, which means that in D2 segment, my lords, there are actually 3 buildings. It's a cluster of 3 buildings. So D2, then P sector 2, K1 and CFC. Now, all of them are cleared under my environmental clearance of 12th October 2017. Your Lordship has that heading. The statement made to the court was that that we are not covered by environmental clearance. Please just see this table, my lords. We have an environmental clearance as far back as 12th October 2017. Now, for D2, the built-up area, which was permitted under that environmental clearance, we have given you 54,958.25 square meters. It is a building of S plus 14 floors, and we've given the details. Height is 45 meters. Just keep that in mind. Height is 45 meters. Then please go to the second building, P. That environmental clearance, again, under 12th October 2017, it's a 70, the meters in height is 70. Ground plus 2 parking plus 21 upper floors, 13 It's 1,32,036 square meters. K1 is the third building, 60,934.38 square meters, 70-meter height building of ground, 2 parking plus 21 floors. And CFC 8 is 12,029.63 square meters, ground plus 4 building, height 15 meters. Now, please just have a look at, please take the right hand, extreme right
In
hand,
your chart, Mr.
this table
Diwan,
chart. Yes.
In your chart, you are saying as per amendment sought on 29th September.
So now you're absolutely right. Now this is, yeah. Yeah. And extreme right hand column shows that we are completely within the parameters.
Your prayers for amendment
Yes.
really has not triggered it.
No, it's not triggered. That is pending. We are within the parameters of height. We are within the parameters of built up area. And you may have noticed that in the new application, we are actually shrinking at some of the places we are building narrower buildings.
You're vertically growing.
Yeah, we're growing. But yeah, now all of that will be within the sanction plans. It's in terms of sanction plans. It's in terms of the environmental clearance. Now, this is an ongoing project, my lords. This is an ongoing project. I am giving a statement and an undertaking that we will not exceed the 2017 EC either on built up area or on height. You may record our undertaking, our director will furnish.
Till the time you get clearance.
Further revise.
Until that new EC is given. Now, this gentleman, after being dismissed,
Justify this.
how is this?
But kindly have the notification at 159. My friend has only, there are 4 aspects to the notification. They are focusing only on 2 and not the one that is. The matter has been examined, same referred to expert committee. The committee examined the matter and after due deliberation was of the opinion that the words no change in built up area, floor area ratio may be reworded as no increase in built up area, floor area ratio so that the building projects would reduce their built up area, floor area ratio subject to, please note this, no increase in pollution load may not be required to seek EC amendment. So what is the substituted, my lords, para 5, next para. The substituted para 5 is accordingly matter has been examined and it has been decided that any change in configuration, planning, design of the appraised building project for which EC was granted shall not require amendment in EC provided there is no increase in built up area as defined, no problem. Total excavation of earth, height of building. Now please note 4. Water consumption, sewage generation, waste generation, so as not to require any changes in the already approved EIA and EMP. Further, there shall be no reduction in the open spaces. Now, please see their own EIA, and I will show, my lords, in their application how both wastewater consumption and sewage consumption has gone up. Please.
How do you say that this? Let their construction
Yes.
be subject to the limits prescribed under the 2017 notice.
Not, that's what their limits, that's what I'm saying. My friend, my lords, has concentrated on only one aspect, height. Height is only one of 4.
Followed your submission. But what Mr. Diwan proposes
Yes.
is that his client will restrict himself to all the parameters of the 17 EC till the amended EC is considered. And
I have 2 responses, lords, if I may, my lord. One is in the 2017 map, which is at page 440. All these sectors are shown as future proposal. They are future proposal. This is a bit of a misnomer, my lords, to say I have not exceeded height, I have reduced my floor area. But the notification itself, why has he gone then for an expansion EC? If he felt, my lord, that he was within the four corners of 2017, there is no
Doesn't
need.
say that. It doesn't say that.
But he has gone and the
He has
SCIA is
gone-
pending that.
He has gone because, forget about your sewage or otherwise.
Yes.
His height of the buildings changed.
No, it's reduction. There is no change as such, my lords, adversely. So he is really.
45 meters go up to 70 meters.
As long as
I
there is
have
no
to go.
increase. But partly, there, some of the buildings, there'll be an
So,
increase.
sir, there have been increase
Therefore, my
in
lord-
certain buildings. There have been build-up area alterations.
I agree.
Reduction as well as
Very
expansion.
well, my lord.
And as you rightly indicated, there may be other areas of water consumption, pollution load, etc., which are at variance. The EIA assessment, etc., will take care of that.
Therefore, it means, my lord, that my learned friend is asking, pending an EC, let me construct. That is unheard of.
Pending an EC, he has the right. His EC under 2017.
Can I just show these charts, my lord?
They are saying it, we will be constructing
As
only
per
to the level
2017.
for which we have been granted EC.
No, as long as it,
That's why
because then
that
that
this injunction will not stand in the way of their construction. A
Showing the same layout.
my lord, just kindly just see what I've sent you. You given them copies? Just see this for a moment, my lord. Just one example. Kindly have D for an example.
What is even?
On the left-hand side is the 17 approval. It says D2 future proposal.
In 2017, it was future.
In 20
I've started construction in 25.
In 2020, this is before
My-
2024.
If my learned friend would have been genuine, he would have attached the proposal. He misdeclared before the court. If we see their petition, ask him to show where the proposal is, the word future uses. It's not there.
It is
It's
there.
in my
Page
IA.
440, it is there.
Show me the one page where the proposal is, and I'll show what the proposal. Factually wrong.
These were proposed buildings in 2017. He started construction in 25. There are 300 buildings.
Lords, if this is the basis of the 2017, that is one aspect. Second aspect, my lord, which is more
Yeah,
fundamental,
finding us-
if you have, my lords,
Exactly.
if you have tweaked your plan, which has an impact on the environment clearance, with great respect, my lord, then till that clearance is granted, you cannot proceed. Otherwise, it's putting the cart before the horse.
You would have agreed, provided the 2017
Yes.
clearance has been exhausted and they are going for an expansion.
We are not.
It's not a question of
Kindly
2017 clearance
see
being exhausted.
kindly see their application at 154. It says fresh terms of reference. Please see their own application.
Fresh
It's not my
terms,
documents.
sir, fresh terms of reference bound to happen
Yes.
because 2025 clearance has modifications and alterations. What we propose to
Lord,
do
if you see
is
my-
not to permit them to go into that modification, but restrict them to the 2017.
The fundamental question is,
Until.
Yes,
and
if
if and when.
permission is granted.
Brother, we have heard mention of constitutional parties. Yes.
I'm sorry to interrupt, my lord, the chief justice. Can I make one suggestion, my lords? The NGT has not considered anything, my lords, considering it's premature. If your lordship finds it appropriate, let it go back and let them examine it properly, my lord.
But then,
Back to NGT.
Yeah, but-
Subject
But
to-
make it clear, well, that there is.
Without
subject to
prejudice
that-
your right, without prejudice to your right to raise objection regarding maintainability, etc.
Yes, but please vacate this injunction.
Yes,
People
yes.
are
But subject to that undertaking
People are
that my
there.
learned friend gave.
absolute
Subject to his
undertaking.
Modified as per the undertaking.
Beyond 2007.
So I think we dispose of the main case itself.
Yes.
This appeal is directed against the
Audit
order dated
22/4/26.
22/4/2026/5, the National Green Tribunal.
Western one.
Yes.
What's one number? Page one.
The original application filed by the petitioner in limine,
Yes, sir.
in limine.
Yes.
Notice by issued and pursuant thereto, one senior counsel for the parties have been heard. It seems that there are some debatable points made by the petitioner, which may require a fresh hearing by the NGT, or subject to the objections that may be raised by the respondents on merits as well as on the maintainability of the OA.
Please.
Consequently, the appeal is allowed in part, the interim order of the NGT is set aside, and the matter is remitted for a fresh identification of OA number so and so so. Next paragraph. As regard to the interim direction issued by this court on 3rd July 2026, the said order is modified. It is clarified that it is not so clarified. It seems that the respondent has the respondent builder cum developer has a valid environment clearance dated 12th October 2017 for a built-up area of 554,948.
The number of variation?
No, that's for each building.
It's for each building, permitted to construct strictly in terms.
Yes, that's right.
It is clear that the respondent builder cum developer has an environment clearance dated 12th October 2017 to raise construction up to the height of 44.
Yes.
Terms of that EC.
Correct.
The respondent shall therefore be entitled to continue with the ongoing project
Within these parameters.
strictly within parameters of the
2017
EC.
EC.
Not what is applied for.
No, strictly in terms of 2017.
What should make it original? What should say original?
Original, that is the
Original is.
This will be subject to by pending application.
However, subject to the revision of the EC for which the respondent developer has already applied.
Please.
Yes.
Yes. Grateful, deeply obliged.
54, my lord, this is an application for early hearing, item 54. My lord, my early hearing application had been previously allowed. My lord, there is no allocation of bench in that matter because justice.
Early
My lordship, I filed an MA today. My lordship had allowed the MA to be listed tomorrow regarding the movie Mahaprabhu Jagannath. I have also filed an MA, my lordship, just requesting it could be listed tomorrow. My lordship had allowed an MA to be listed tomorrow. Grateful, my lordship.